I'm in the middle of cross-examining a medical expert in a medical malpractice trial. Why would the defense attorney get up in the middle of my question and yell out, "Objection, Judge"? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. The reason why a defense attorney is going to jump up out of his seat and yell out, "Objection," is because he believes that something I am asking this witness is inappropriate. That's the bottom line. An attorney has a legal obligation to protect his client's rights. And now if he thinks that I'm asking a question that might prejudice his client, he has an obligation to stand up, make an objection to the judge, state the reason for the objection, and now wait for the judge to rule. That's an obligation that every attorney has. Likewise, I do the same thing. So now if I hear my adversary asking a question of a witness or trying to introduce a piece of evidence that I think is prejudicial and should not be introduced, I have a legal and moral obligation to stand up and yell out, "Objection!" I have to make my objection known. And then the judge will likely ask the reason, the basis for my objection. And there are many, many different types of objections that can be made. One is hearsay. What's hearsay? Well, it's something that somebody overheard somebody else say, and now he's telling that to the jury. Well, why is that a problem? It's a problem because the person that he overheard saying it isn't in court, and we can't test whether or not that person is really credible and truthful. Another objection is relevance. Now, what does that mean? "Judge, objection, that's not relevant." Well, maybe the question has nothing to do with the claims being made. So let's say, for example, I'm questioning a medical expert at trial. If I were to get up and say, "Excuse me, Dr. Jones, how many times do you beat your wife?" Objection! Irrelevant! Improper! Why? Because that's got nothing to do with the issues in this case and what this expert is talking about. It's got nothing to do with my ability to properly cross-examine this particular doctor, unless, of course, it does. If you sit in the back of a courtroom and observe a civil case in New York that's on trial, you will see attorneys all the time jumping up, yelling out "Objection," and then pay careful attention to what the attorney is objecting to. Is it relevance? Is it hearsay? Is it some other objection? Because then you'll get a clear understanding of what he's doing and why. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these civil lawsuits here in New York. You know, I understand that you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.